Hi everyone, and welcome to today's webinar, Appealing a Decision about the Disability Support Pension. I'd just like to start by acknowledging the traditional owners of the land on which we meet today and pay our respect to elders past, present and emerging. Now today's information is for community legal education purposes only. I'm just going through a few housekeeping slides. The webinar is recorded today, so you will be able to get a copy on our YouTube channel in the coming months after it's been captioned. You can find our YouTube channel through our Information for Community Workers and Carers page on Legal Aid Queensland's website. If you have any technical issues, the number's on the screen now. It's 1800 136 402. Okay, for those of you linked in online, you'll be able to download the 3 handouts now. One of them is the invitation, the PowerPoint slides, and a Social Security handout. As you have questions, you're welcome to type them into the questions box if you're logged in online. I know I've got a couple of questions from those who have dialed in via telephone already, and we'll hold the questions until the end. All right, we'll be running a few polls. So the first poll today is, which region do you work in? We're just interested to know if you're from Southeast Queensland, Far North Queensland, Regional Queensland, or from outside of Queensland. I'll just give it another minute. I can see there's quite a lot of people from outside of Queensland today. So I'm joined with Justin from AAT and Steve from Basic Rights Queensland and Bryony from Legal Aid Queensland. So as they get to their slides, they'll be able to let you know if it's relevant to those of you from outside of Queensland as well as within Queensland. Okay, I'll share those results with you if you're interested to see who the audience is today. And one more poll before I hand over to our presenters. How would you rate your knowledge of the disability support pension? Do you know a lot about the disability support pension? Have a good or limited understanding, or perhaps you haven't heard of it before? Most of you have a limited or good understanding. I'm sure you'll learn a lot more today as we go through the presentation slides. I'll quickly share that with you now. Okay, and as I mentioned, we've got Bryony from Legal Aid Queensland, we've got Steve in the middle from Basic Rights Queensland, and we've got Justin from the Administrative Appeals Tribunal. I'll pass over to Bryony now and she'll go through the outline with you.
So today we're going to be looking at an overview of the disability support pension. We'll look at the online interview tool, which is being developed by the Administrative Appeals Tribunal. Who's it for and how can it help? We will cover some examples about the program of support requirement. We'll also be looking at what sorts of orders can be made by the Administrative Appeals Tribunal, and then we'll talk about how people can get in contact with Legal Aid Queensland in relation to social security matters and Basic Rights Queensland as well, and what sort of servicing they provide.
Thank you. So my name's Justin Tui. I'm at the Administrative Appeals Tribunal, and my role there is as the Director of Alternative Dispute Resolution. And what that means is the particular part I work in. A few years ago, the Social Security Appeals Tribunal and the AAT were amalgamated, and now there are 2 levels of social security appeal within the one tribunal. I work in the 2nd level of the appeal. So people go through a 1st level of appeal in Social Security Child Support Division. And if they're not satisfied with that outcome, they can appeal to the 2nd level of appeal where I work. And the role I have there is to conduct conferences and conciliations, and they're our main alternative dispute resolution processes. And through that process, we have a confidential discussion between the parties, which we facilitate, and we try to resolve matters if we can, or in parallel, we make sure that those matters are properly prepared to go to a hearing before a member. And I'll just give you a little bit of an overview there. So disability support pension is a very large component of our work. There's lots of different jurisdictions that can come to the Administrative Appeals Tribunal, from tax matters to workers' compensation matters. But social security appeals are a large proportion of our work, and disability support pension in particular accounts for the largest component of that social security work. And it's something in our experience then where as a sector that we're dealing with, that you'd be very familiar with, people applying for the disability support pension are some of our most vulnerable members of our community, and they're often expressing a lot of difficulty in understanding the requirements for disability support pension. So one of the things that I wanted to talk to you a little bit about today was a disability support pension interview tool that the AAT has developed, particularly for community workers like yourselves. And I'd be interested just to know then whether that's something that you have made use of. And so we'll just launch a poll about that.
Yeah, so that's up and running now. You can see many of you haven't used the tool before.
Okay. Yep. So
Justin will be able to give you more information on how to use that today, and, and hopefully you'll be able to go away and test it out.
Yeah. Yeah, so it is early days for this tool. We have only recently launched it. We'll skip this poll because most of you have said that you haven't used the tool. So yeah, it is relatively recent that we've launched that. What we're trying to do there is really target the audience of community workers, because there are a lot of key misunderstandings that we see, recurring themes coming through. And initially we were trying to develop this tool with potentially the audience of disability support pension applicants directly. But what we found was that we were not able to get it to a level that we were satisfied with, that was going to be very accessible for that vulnerable group. So we switched tact throughout our testing and decided that we would target instead the community worker sector, so that you could potentially work with a DSP applicant to step through what some of these requirements are, what some of the information is that's needed, and from working through that tool, get some summaries about where the main gaps are in the current information. And one of the other principles that's informed that tool as we go through it is that there are some issues that become quite complex, can be legally complex or medically complex, and when we hit those points, we're really referring people off to Legal Aid or Basic Rights Queensland or others around the country who provide this sort of specialist advice. And the other things that we're trying to do in there is that we are, the AAT is independent and neutral in making these decisions. So we're trying to make sure that we're providing links to the DHS public materials, as well as the good resources that others have developed. And it's not a substitute for the different legal advice clinics that we have operating around our various registries. So it's something that we see as complementing that and maybe broadening the pool of people who are able to provide some of this practical support and assistance to the DSP applicants. A sort of example of, it's based, the tool is based off survey software, so it uses that sort of survey functionality, meaning that people are able to step through some questions. And this would be one of our most common areas where we hear that people do not know about this particular requirement, about program of support, and what information they need to provide about that program of support. And so when people have entered in some information about when they applied for disability support pension, that information keeps getting repeated throughout the survey tool to keep reminding people that there's the point in time that they need to provide information about is when they put in their claim. And that can sometimes be quite a while ago by the time it's at the AAT. It also then, you can see there, it links to some forms the Department of Human Services have, and then it asks questions about that particular program. From that, filling out that sort of information, which there's similar checklists then for the medical information, it can produce a printable summary page. So based on all of the person's answers as they've worked through this, it can give them some feedback on what they have said, and therefore also identify some of the areas where they might need some more information. And so that's designed as well to be something that with those summary pages people could print out, or they could come back to later, and they could take some of this along to either their treaters to show some of the gaps where they need some more information about the medical side of things, or they might take it along to their program of support provider as well and seek more information from them. So it's overall, we've had it in place since the end of March. Most recently, we've updated that. I think we're up to about 87 times it's been used. I think we'll track towards about 100 or so this month. We're still thinking of this as a bit of a prototype to see how it's used. And if people do complete the tool, there is a separate set of a couple of questions asking for feedback about how we might improve the tool as well. So we are thinking of it as a working prototype and something that we'd be interested to see whether people are finding this useful, or if there's things that we need to do to change it. So I think that's most of what I wanted to cover. I can hand over to Steve from Basic Rights Queensland now.
Hi, Justin.
Thanks very much.
Thanks, Justin. I'm Steve Irvine from Basic Rights Queensland, and I'm one of the solicitors at Basic Rights Queensland. As the slide suggests, we're a community legal centre and we're multidisciplinary service, and what that means is that we have senior social workers also who provide advice and support for people who contact us. We're a free service, and unsurprisingly, we deal mostly with disability support pension matters. Having said that, the centre is designed to deal with anything in relation to social security law, or any dealings with Centrelink. We can provide advice in any of that, but we do predominantly provide advice on disability support pension. We deal with people at all levels. Mostly we're dealing with people with certain vulnerabilities, and we can provide assistance, and we can provide advice at basically any level. But usually when people contact us, they're contacting us at a very, very early stage or a very late stage, and it's mostly about information. And the people who contact us have very limited information about how to appeal or about disability support pension. And Justin pointed out program support. You know, a lot of people don't know what a program of support is. We can provide a bit of guidance on that. We can provide guidance on how to appeal and what you need to provide in order to not be successful at DSP, because you can't say, because it's a subjective process, but to help you or help your client on the way to providing the correct information so that your application or your client's application can be considered to its fullest extent. And that can be a bit tricky. Not many people understand that with disability support pension, you're dealing with not only a medical criteria, but dealing with a legal criteria as well. I spend a lot of time trying to explain the difference, and it can be very difficult sometimes, about the difference between fulfilling the legal requirements and fulfilling the medical requirements. Now, the advice that you'll get from social workers and from our solicitors at Basic Rights will be as down to earth and as direct as we can give it. We try and speak at a non-legal level for want of a better description of that, and how best, and we try to how best we can provide the information to people at any levels. We do advocacy. For particular for certain people, and the guidelines are we have certain casework guidelines, and it's a resource-based thing. Given the number of inquiries we have and the number of appeals that go through, it's impossible for us to actually deal with every one of them. So we have a criteria that is on the web as you see it there, and the criteria is basically aimed at vulnerable people and those who cannot advocate for themselves correctly, or in the terms of the people that you're representing, providing that advice and helping you to help your clients to appeal from that situation. But we're contactable by telephone and on the website. We provide telephone advice 4 days in the week, sometimes 5 days, depending on our resources. But mostly we provide telephone advice as a first contact every morning, Tuesday to Friday, from 9:30 to 12:30. That's about all.
So I'm hearing that Basic Rights Queensland does advice as well as casework, including advocacy.
That's right.
It's any kind of Centrelink issue at any level of appeal. So if somebody's just had a decision made by Centrelink, they can get booked for advice, or if they're at the Administrative Appeals Tribunal, General Revision, that second tier, they can get advice as well.
More limited at the second tier, and yeah. I did neglect.
Oh, I guess that's just the advice though. But then you've got the casework, which is subject to casework guidelines, and not everybody gets that.
That's right, and we will look at representation on those casework guidelines.
So people need to meet the casework guidelines in order to get a representation service.
Yeah, unfortunately, we can't guarantee everybody representation for the reasons that are
because limited resources in the sector and a lot of needs they have to target.
That's right. Yeah. And we provide quite extensive advice at times at the authorised review officer stage, which is the first review stage of Centrelink, and then after that, outside of Centrelink, to the Administrative Appeals Tribunal. Now, we predominantly represent in the first level, the tier 1 as they call it, and we can provide, like I say, limited advice and limited representation at the second level, tier 2.
And BRQ does advice about all kinds of Centrelink issues, but most of the questions end up being about disability support.
Most of the questions are disability support pension.
Cool.
It's been like that for a number of years since I've been there. It's been predominantly about disability support pension.
Do we have a contact details slide for BRQ, or I can't recall if I saw it in there. So the phone number is 3847 5532.
That's right, and there's a 1-800 number which has.
I never remember the 1-800 number, but the website's brq.org.au for Basic Rights Queensland. brq.org.au.
You're spot on, Brian. How do you know that?
Full disclosure, I used to work at BRQ.
And that's why she's kicking me out of the
next slide, shall we? So This is Bryony Walters. I work at Legal Aid Queensland. I do social security appeals matters within the civil justice section of Legal Aid Queensland. Legal Aid Queensland does a lot of different work, but I'm really only speaking to the work that I do today. So broadly, Legal Aid Queensland, the mission statement, the vision is to support people who are financially disadvantaged in relation to legal issues. We do advice clinics. We're a little bit different to BRQ in that BRQ people can self-refer directly to the organisation, but at the moment the way that Legal Aid social security advice servicing works is that we run clinics at the appeals tribunals and people are referred into those clinics and booked into those clinics through the registry of the tribunal. So I see people who already have an appeal that is before either the first or the second tier of the Administrative Appeals Tribunal generally, whereas Steve would be talking to people who have made a claim for a payment or have just been knocked back a lot of the time, as well as people who might be before the tribunals already. So that's a bit of a different referral process. So people can self-refer to BRQ, whereas they're only getting referred to speak to me generally if they've already got an appeal running. One of the differences as well is, well, a similarity is that we do advice and representation as well. And I guess we have casework guidelines for representation services in a way, because Legal Aid Queensland has grants of aid for appeal matters. So somebody might get advice, and then if we want to open a file, we might suggest to somebody that they make an application for legal aid. Those applications for aid are subject to a merits test and a means test. So it's very similar to the casework guidelines that BRQ has. Legal aid is looking at whether or not people are financially eligible for a grant of aid. That's the means test. And then the merits test has a couple of different components to it. One of them being that legal aid would need to take the view that the person's appeal at first glance has a reasonable prospect of success. When I'm advising people though, when they're in those tribunals, I'm often talking to them about their prospects on a new claim as well as in relation to their appeal, which can be important. Community workers or lawyers from other community legal centres can contact lawyers that work in the Social Security Appeals Unit directly for guidance or support around client matters that they're dealing with. If they've got a client that they're supporting who has a Centrelink issue or a disability support pension issue, they can make contact with me or with my colleagues directly. And that's the Social Security Appeals handout that's in the documents that are available through this webinar, is a flyer with contact details to make contact with me or Catherine Ewer or Genevieve Nuttall directly, and we all do social security appeals matters.
And that flyer is just for community workers only, not to be passed on to clients.
Because it does have direct phone numbers, yes. But if clients want to make contact with Legal Aid, they can get in touch on, we have contact details on a later slide, but they can make contact with the call centre. If there's any level of confusion about where to go or who to speak to, Legal Aid call centre can give people information and referrals. So the operators in that call centre will have details for Basic Rights Queensland, will have details for the Administrative Appeals Tribunal, and will be able to clarify where people need to go for what sort of assistance they need. All right. Oh, so this is just a list of locations of legal aid offices. One thing to note in relation to this particular topic today is that all of the lawyers that do the social security assistance are located in the Brisbane office. Sometimes the fact of having a local office closer to somebody can assist if they have documents that they need to hand in or if they want to hand in an application for aid face-to-face. So I think it's good for people to know that there are local offices about, if there's workers who are outside of Brisbane. If they don't already have a relationship with those local offices, it can be good to get to know who's there. And so there's contact information there for Legal Aid Queensland. So the general call centre phone number is 1300 65 11 88. There is also a specialist Indigenous information line And there's also a phone number you'll see at the bottom there, which is 01300, which is for people with follow-up questions about an application for legal aid that they have already submitted. So the legal information and referrals line, the main line for Legal Aid Queensland up the top is 1300 65 11 88. The Indigenous information line is 1300 65 01 43. And the grants information line for questions about an application for aid you've already submitted to Legal Aid Queensland is 3238 3900. And before I forget, I'll mention that we're not the only people in Queensland who provide assistance in relation to social security matters. There is a limited service that runs out of the Townsville Community Legal Centre as well, which might be worth noting for people who are in the far north.
It's actually well worth noting Townsville Community Legal Centre. It provides a social security advice. Yeah, well worth noting.
A very experienced colleague, Bill Mitchell,
yeah,
works out of that centre, and I think has been there for more than 25 years.
Yes, long time. Yeah.
Okay, any questions? We've got quite a good list of questions here already. So if you've got any extra questions, now's a great time to type them in, and we'll head on with the questions that those on telephone and online have already asked before the webinar. So we've got a couple who are linked in on telephone, and they have asked, is this appeal affecting the disability support blind pension?
I think the answer to that is that the main thrust of the webinar today is to introduce the interview tool that the AAT has developed to support community workers who are working with people who have a disability support pension appeal. So the thing to say there, I think, is that there's been no change to the eligibility criteria for disability support pension or for disability support pension blind. So blind pension is granted under Section 95 of the Social Security Act, and then there's eligibility criteria for disability support pension as well under Section 94. So there's been no changes. We're not speaking today to changes to the eligibility criteria for DSP.
At the AAT level, I'd say it's fairly rare for me to have appeals coming before the tribunal in relation to the blind pension. So that's much less common. At our appeal level.
I would say from my perspective that the eligibility criteria for DSP blind is a lot more straightforward under Section 95 than under Section 94.
And I'd mention as well that with that DSP interview tool, if you go to the aat.gov.au website, the easiest way to find it is just to type DSP into the search bar. It'll come up as the first hit. And there is a audio reading tool that links to that DSP tool as well. So you can make use of that. I'd be interested in feedback about that as well.
Okay, great, thank you. I've got a question about NDIS. So a community worker is wondering where NDIS fits within the disability support pension. Is there an overlap there? Or do clients on the disability support pension eventually move into the NDIS space?
So NDIS can be appealed to the AAT as well. My understanding is that they are two separate schemes, and I'm not aware of any plan for those schemes to be merged. So people can apply for disability support pension and also be eligible for NDIS, and they're separate frameworks, separate tests, separate decision makers that are involved in those. The NDIS isn't an income support scheme like disability support pension. It's looking at the reasonable and necessary supports for someone's participation in the community and at workplace. So there is potentially some overlap in some of the intentions of the different schemes, but at this stage they're treated as two separate decision-making frameworks.
Thank you. And Justin, someone's commented that they feel like there's a bit of a grey area in the assessment process when it comes to mental health. Do you have any tips for having success with the disability support pension applications for people with more complex mental health?
Yeah, look, I agree mental health is one of the most frequent issues that we see at appeal, and one of the more complex areas. And that is because there are some requirements that changed in the last few years about that. In particular, that the diagnosis of the mental health condition has to, can still be by a general practitioner, but it needs to be with supporting information from either a clinical psychologist or a psychiatrist. And what we're seeing, I would say, is that many people might have just had the diagnosis from a GP, or with GP and might have had their treatment and management through a psychologist, but not a clinical psychologist or a psychiatrist. And for the disability support pension, when you look at the timing, they have to have had that diagnosis pretty much at the time that they put in their claim for disability support pension. And lots of people are finding out afterwards that there was this requirement to have the diagnosis from the clinical psychologist or psychiatrist. The other thing, of course, is that yes, there is questions about stabilised in mental health in particular can be a complex question, whether something is fully treated, diagnosed and stabilised, because you can often have very fluctuating symptoms, and there is a way in the legislation to deal with that fluctuation. I think that there is a misunderstanding at times that the ordinary meaning sort of stabilised it's a different definition in the actual legislative framework about what stabilised is.
In the Social Security Policy Guide, it specifically states that stabilised doesn't take its ordinary meaning in this context.
Yeah, so lots of people will think that symptoms go up and down, and maybe always will. And so they say, how can I ever be stabilised?
Especially if you're talking about a disorder that's characterised by fluctuations in level of functioning, like bipolar disorder.
Yeah. And then, so in this framework, though, the sort of extra tail sort of to the question that you need to ask about stabilisation for a mental health condition is there treatment that's planned that's likely to have this significant improvement for somebody? And that it's that tail end of the question which I sometimes see hasn't been resolved even by the time it's at this second level of appeal at the AAT, and we need a little bit of clarifying information about that. So yeah, it is a more complex area, and that'd be one that certainly recommend getting some advice about how you ask the treaters about that information. And that's where I think Basic Rights and Legal Aid do some really good work about asking the right questions to get the information that's needed for this framework.
And I have a template, like a template for a clinician to use when somebody's making a new claim for disability support pension, when they have a mental health condition, which is easy for me to share with other workers if they make contact with me. Sometimes when I'm working with somebody and giving them advice, I'll put together some more specific tailored questions for them to take to their clinicians to help try and draw out the information that would be relevant to a decision maker. But in terms of tips on how to, if there's people who are routinely working with people who have mental health conditions who are having issues to do with disability support pension, it would probably be well worth your while to get in touch with me in order to get that resource so that you can, and once you have it, you can adapt it in whatever way you like, or make contact with me ongoing about sort of novel issues that arise in client work that you're dealing with.
Yeah, Basic Rights also have, we have a number of tailored letters for medical professionals for our clients or the workers to take with them to the doctors that actually pinpoint those areas like diagnosis, whether or not the definition of fully treated and stabilised, because it can be quite confusing And people like Justin correctly said, like, most people miss that significant improvement. Treatment is going to provide a significant improvement. Because most of the queries I get is, well, my doctor says I'll never be stabilised. But the definitions in the legislation are quite different to the medical definition, and it's a bit trying to understand the differences between those.
So Stephen, Bronnie, do you think you could help? We've got a couple of people who have asked about when a medical condition isn't recognised in Australia, such as Lyme's disease, and someone else is having difficulty breaking through DSP for epilepsy. Are these things that you could help with?
With whether or not a condition is recognised as a diagnosis, I think ends up being an issue that's sort of sitting out more in the medical space rather than the legal space where we're giving advice. So there is a requirement when you're looking to get DSP that the condition is diagnosed. I would wonder whether or not an issue arises if there's no diagnosis from an Australian-based medical professional. It's maybe the thing to say is that any person can make a claim for disability support pension at any time. It was sort of touched on a bit by Justin before, the idea that a diagnosis might have had to have happened at the time that a claim's made. And I noticed that on the summary page on an earlier slide, one of the references was to the idea that new claims can be made at different times. So to bring that all together to make a point, a person can make a new claim for DSP at any time. You don't have to know that you're eligible before you make an application. In fact, you could never know if you're eligible before you make the application, because you're looking for that determination to be made by Centrelink or by a tribunal that you are eligible. So if somebody has a diagnosis of Lyme's disease or believes that they have Lyme's disease, I guess I can only encourage them to test their eligibility by making a claim.
And the same with epilepsy.
With epilepsy, it's probably, if somebody has an issue to do with epilepsy, I'd probably encourage them to contact me directly. Epilepsy generally, if it's reasonably controlled by medications, then it can be a little difficult to get onto payment because you tend to need to have a reasonable number of seizures despite being stabilised on medication. You sort of need to get to a point where the clinicians that you're working with think that where we're at right now in terms of medication and treatment, it's not going to get any better in terms of controlling seizures. But then when you can look at how many seizures is the person continuing to have, the bar is relatively high. But a lot of people who have epilepsy have other conditions that they're living with, which may help them to get onto a disability support pension. So getting advice from a place like Basic Rights or from me can help, I think, to figure out a decent strategy for that person.
And just a reminder about Bronnie and Steve's contact details. So you can email webinars, webinars @legalaid.qld.gov.au, and we can pass your questions on to Bronnie and Steve, and then they may be happy to share their phone numbers and email addresses from there as well. But you've also got Bronnie's direct details through the handout, Social Security handout, if you'd like to download that. Okay, so could you please explain the points system that Centrelink uses as a part of the assessment for a disability support pension?
And it's probably one of the biggest questions that we have. Quite often, the first contact we'll have is Centrelink says, I don't have enough points. And when you investigate it further, you usually find out the person you're speaking to doesn't know what the points are. And, you know, that's problematical anyway. But now the point system, it derives from the impairment tables that are part of how Centrelink, or how the job capacity assessment and how the Centrelink team will assess a person in the process, the disability support pension process. Now there's 15 tables, soon to be 14 tables. There's a table, and it's related to certain parts of the body and certain functions of the body, and the keyword is function. It's about functionality rather than diagnosis. So when you've applied and you have a diagnosis and you're found to be fully treated and stabilised, then you refer to the tables to see how you actually function with your impairment. And each impairment table has a rating of 0 to 30 points. Now, For the disability support pension, you need to have 20 points to even look at qualifying for disability support pension. And the 20 points can be derived in two ways. It can be an accumulation of the points from a number of tables, or 20 points on a single table. The 20 points on a single table is easiest to deal with because it usually means that you're classified as having a severe impairment under the legislation, not medically. And people often get that confused. Under the impairment tables, you have 20 points on a single table. It means that you have a severe impairment. Now, what it means legislatively, because we're talking about a legal process here, is that it takes away that requirement that Justin had on his slide before about that program of support, the need to participate in the program of support. Okay, so that part is wiped out, if you like, if you have 20 points on the single table. If you have accumulated 20 points across a number of tables, there's two other important parts of the legislation that you need to fulfill, and that is that the notion of a continuing inability to work more than 15 hours a week, or 15 hours a week, and have participated or engaged in a program of support. So the tables look at, and it's important to mention that they're a guide. They're not the be-all and end-all of, and sometimes they're treated like that. But there's a certain specific things like, say, the mental health table 5 will ask questions, about, the client's ability to self-care, for example, and things, and there's a number of questions that fall under there. And I've got lost what I was going to say.
Sometimes I find it useful because somebody might approach me and say, I made an application for disability support pension. They've told me that I don't have any points, but I'm very impaired. So how do I make sense of that? And so I explained that there are rules about getting points at all, and then there's rules about how many points you get. And so in order to get points at all, you need to establish that the condition is fully treated and stabilised in those specific terms set out in the law that we were touching on earlier. But then how many points can you get once you've cleared that barrier is based on the impairment table. So, sometimes I'll talk to a client and they've got a copy of the impairment tables and they've said, I've gone through this and I'm worth 30 points, but they've given me none. How do I make sense of that? And so the issue invariably in that sort of situation would be that there's not evidence before a decision, not sufficient evidence before a decision maker so far that those conditions are unlikely to.
Yeah, I mean, and that's it. The evidence of the functionality on the points table, it needs to be backed up by evidence, from your medical practitioners that you cannot perform or you cannot perform the function that's required under the tables before you can be awarded any points. But like as Brian pointed out, and as I said at the beginning, if you like, it's the third part of that area of the criteria, the diagnosis, whether you're fully treated, stabilised, and you need to fulfil those two requirements before they'll even look at giving points. Before you can get it.
Yeah, and I could agree with Steve that, like, from a legal point of view, having 20 points under a single table is a lot more straightforward. But I'd also say it's actually a very high bar to meet. If you look at the 20 points under a single table, it is this severe level of impairment, which on its own is going to stop a person doing 15 hours of work a week, any type of work, anywhere. So it's it's probably more severe than a lot of us would think of, I suppose. So for me, at the level of appeal I work at, the more common thing for me to see is that people have multiple impairments across a number of different tables, and they might have 10 points under one and 5 under another, and doubtful, or maybe 5 or maybe 0 under another, and that can add up to the 20 points. And that's where you get this other requirement about having participated in a program of support, and that's something that people are often not aware of, that there is that requirement, and they're meant to have done active participation in that program for 18 months in the 3 years prior to claiming, and those programs are those disability employment type services that are aiming to improve improve people's ability to work. There's some exceptions to that. They're relatively complex, and I don't see them that often. That those exceptions come up. Probably the most common thing I see is that people have a medical certificate saying they can't take part in that program, and because of that, they haven't been actively participating in that program. And that's a very difficult thing for a lot of people to understand, is that even though they've got that medical certificate, that is not counting towards this active participation. It's effectively stopping the clock of their participation. And so sometimes the more important thing for someone to be asking their doctor is not whether they can participate at all, but what things can they do. So then they would be able to participate in a program of support and have it adjusted and tailored to what they can and can't do. Then that could count towards active participation. It might improve their ability to get a job, but at least as well for this eligibility for disability support pension, the clock is running for them when they're able to take part in the program.
So sometimes I find it's really important to clarify for clients that the program support requirement is one of the core eligibility criteria for disability support pension, and that while they can be exempt from that requirement if they get 20 points on one table, that if they have a medical certificate which has given them an exemption from the activity test for New Start allowance, that's not the same as having an exemption from the program support requirement. Like you said, having those medical certificates has essentially stopped them from fulfilling the program support requirement.
Because the program provider says, no, we can't have you involved in this program while you've got that medical certificate.
Speaking of the medical certificate and components of the DSP application, is this something that should be filled out by a medical professional or by the applicant themselves, the medical component, just the medical component of the DSP application?
There used to be two parts to a disability support pension application. There would be the DSP claim form, and then there used to be a thing called a treating doctor's report, which the doctor would fill out, whereas the client would fill out the claim form, or a support person if the person has literacy issues or impairments that affect their ability to fill out the claim form. The treating doctor's report is no longer a part of the disability support pension claim process, and there's a checklist that clients are given to, and I think it's incorporated into the claim form as well. That's the involvement that a doctor might have, is providing medical evidence, but filling out the claim form itself is generally something that a client would take responsibility for, or would find somebody else in their life who can support them to do that. It might be a little bit outside of the scope of the role of a doctor to fill in that form for them.
Speaking of family support, are there any suggestions you could give people who are looking to support clients and their families going through the application process for DSP? We've had a lot of people who are saying that they're having trouble getting conditions such as MS and brain tumours recognised as being stabilised, and they're having trouble going through the steps to receive DSP payments.
I guess if you're having trouble getting evidence together that a condition is stabilised, then seeking out some advice from Basic Aid Queensland, or if you have an opportunity to connect with me, then I can speak to what kind of information, what sort of questions you can pose to a doctor to draw out the sorts of information that are relevant for a decision maker on those questions.
I mean, a good example of that, Justin brought up earlier about fully treated and stabilised, which is always problematic when it comes to an application. But what you're looking at is, in terms of the legislation and medically, is what reasonable treatment the person has had towards the stabilisation. And reasonable treatment has a specific definition that that may mean depending on the level of the treatment and what's to come afterward, that you are already stabilised, even though the medical definition of the stabilised may be different.
And and on the National Welfare Rights Network website, they've got some template letters that can be taken along to doctors. We link to that from the DSP interview tool. There's also a link to a medical checklist that Department of Human Services has developed. And our tool as well tries to go through a similar checklist process that somebody could take along to their doctor to ask some of those specific questions. And because we're doing that in an interactive survey tool based format, then it's inserting the right dates that the medical information has to relate to as well, which is one of those frequent issues that we encounter, is that people, when they're appealing a process, will be putting in new medical information. That medical information will often be focused on how that person's conditions are at the point in time that the reports are made. But we need to be looking at a point in time for the appeal process when the claim was made and how people's conditions were then, which is a pretty artificial and often difficult thing to step through. And that's why one of the things Bryony mentioned before as well is that sometimes people, at the same time as they have an appeal running, they can also be retesting through a new claim process whether the extra information and how their conditions are now after they've deteriorated or had further treatment, whether they're eligible again. Because the legislation is very specific about the time frame that you have to look at. And sometimes by the time it is at the second level of appeal at the tribunal and has gone through a couple of layers of internal review in Centrelink and then to the tribunal and through 2 tiers of the tribunal, it can be more than 12 months has passed since people put in their claim, and then asking doctors to go back through their records to say how were these person's conditions at this point in time 12 months ago can become a complex task for them to do as well.
It would not be uncommon for me to speak to somebody who has an appeal about a claim that they made a year ago where they weren't getting points because decision makers were saying this isn't fully treated and stabilised yet. The tribunal in the appeal only has power to consider the eligibility of that person on the date that they made their claim, or perhaps in the 13 weeks after. So I might talk to somebody, they've got this appeal, it's from a year ago, they saw their specialist last month who said, well, we can't operate on this, there's nothing more that we can do. And so I might be suggesting to that person, well, it sounds like that condition was fully treated and stabilised for the first time a month ago. It's open to you to continue your appeal, even if I don't think that it has prospects of succeeding, but would strongly encourage you to make a new claim now that there's been this change. To get a decision maker to take that into account, you need to lodge a new claim to have your eligibility today looked at, because the tribunal only has capacity to consider how things were a year ago at the time of your claim or in the 13 weeks after that.
Just on that point of making a new claim, people don't understand that you can make a claim at any time. You don't have to wait till the claim that you're actually appealing has ran up. You can make another claim, and it's often advisable to make a new claim during that process. But having said that, I'll clarify that is to make sure that and seek advice about whether or not it may be that you are fully treated and stabilised, or you have got your diagnosis, because it's very date specific. And this is the legal part, is very date specific.
And Steve, would clients have access to an advocate before or after the decision? They come and see you for assistance with this?
We'll always provide the information, but whether we advocate for someone will depend on the criteria. Okay, well, a vulnerability criteria and a merits criteria. So we can't promise everyone that we can advocate for them, but there's other things we can do to help them self-advocate if they're capable. And one thing also to remember about the Admin Appeals Tribunal, especially at the first tier, is it is set up as a self-advocacy service as well, for those who are able to do that. And obviously we work with people who are not always able to do that. But again, we would look at, as I said, we look at the merits of the application first off, and again, as Bryony pointed out, our advice may be you need to make a new claim because this has not been fulfilled. But as you know, we try at the beginning of the process to provide people with the correct information to take through the process as a starting point, and then we can work out the advocacy if necessary afterwards.
And Steve, what options would a support person then have if they wanted to advocate for a young person who's under a public guardianship order?
Yeah, well, we did have a chat about that before. And look, I mean, usually it's I've had no experience with someone under a public guardianship order personally, but it is a matter for probably the public guardian or a referral perhaps to QCAT. QAI, sorry.
Queensland Advocacy Incorporated
right.
has advice servicing concerning administration and guardianship orders. I do note that I have had very little contact like with people who are under guardianship or administration orders over the years in relation to DSP issues, and I have to wonder whether or not generally people would have a level of impairment that has made it easier for them to get on to payment. But if there's a worker who's present who is dealing with that situation right now, I'm happy to engage with that person to help them find the referrals that they need.
Yeah, similar. Yeah.
Okay, thank you. We've got a question. In your experience, has the AAT waived the requirement for participating in a POS before?
Yeah, look, there's been a range of decisions around program of support. It can be a relatively complex area. There has been some decisions. The decisions at the tribunal aren't like a decision at a court, which has this precedent value, meaning that others have to follow the decision that's made. So while a member may make a decision in relation to program of support, each member is an independent decision maker. So, and much of this turns on the individual circumstances in a case. But yeah, there have been matters where a member has said that the program of support requirements don't apply because the program of support is not going to be of any benefit in improving somebody's work, but they're not that common.
I think the thing that I want to say about that is that the program support requirement is set out in the Social Security Active Participation in a Program of Support Determination, which has legislative effect. And that determination sets out a number of ways to fulfill the program of support requirement. The one that we're most often talking about is this idea of actively participating in a program of support by spending 18 months attending appointments at an employment service provider or a disability employment service. We also often talk about the idea that the legislation says that if somebody gets 20 points on one table, then they are exempt from the program of support requirement. There's also another way to fulfill the program of support requirement under the determination, which says that if somebody is engaged with a program of support at the time that they make their claim and the person's impairments on their own mean that they would be prevented from improving their capacity to prepare for, find or keep a job, then that also satisfies the program support requirement. So one of the things to note here is that the tribunal is bound by the same legislation as Centrelink and doesn't have power to exempt anybody from the operation of the Social Security Act or other related parts of law. So it is much more common for the tribunal to find that somebody meets the program support requirement, I think, with 18 months worth of participation, but there are other provisions for people to satisfy the program support requirement, but it's not that the requirement has been waived. It's not that the tribunal has said, well, there's a good reason in this person's case to say that the legislation does not apply.
Yeah, that's a good point. When we are making a finding along those lines, then the tribunal is actually saying that effectively one of the exemptions applies, and that this program of support either hasn't been able to improve someone's ability to work or won't. And so that's, and as I said, it's not very common in any case. It'd be much more common for the way this legislation operates is to say that somebody hasn't had that 18 months of active participation and therefore doesn't meet that requirement. So it is, it is very prescriptive, the different requirements. And some of those things also need information from a program of support provider. So a program of support provider can say that they've done everything that they could for somebody, and there's nothing more that they could do to help improve their ability to work. That's also something that, at least in the work I'm doing, I rarely see.
Yeah.
Okay, thanks everyone. I think that's just about all we have time for today, because it is 11 o'clock now. But before I let you go, would you mind giving the audience just one tip each? What's your top tip, your top takeaway from today's session?
Disability support pension is not a payment for people who have disabilities or for people who can't work. It's a payment that is made to people who have made an application for disability support pension and who have been able to provide evidence that they fulfill the eligibility criteria. So I think reframing it in that way makes it easier for us to problem solve in order to get disability support pension for people that we're working for. It's not about making arguments based on compassion or need or deservingness, even though those things may be true. We're working in a forum where what will be responded to is arguments based on law and evidence, and I respect that not everybody is going to be right across that, so please come and talk to us so that we can help.
Basically, the earlier you can seek advice in the process, the better, and it may save you and your clients a lot of frustration. Like I said at the beginning, most of the time that we speak to people, they're in the middle of the process, after the appeal process, or during, and they've never had any information given to them about points, about criteria. So the earlier that you can get the advice, the better.
Yeah, and I'd echo that, is knowing the range of requirements that there are. People often say that they feel like the goalposts have been moved because they satisfy one requirement, and then find out there's another requirement that they haven't met. So knowing upfront and early what each of the requirements are is something that's very important for people not to go too far down a particular track and find out that they won't be eligible anyway because they weren't enrolled in the program of support at the time that they put in their claim. So knowing about what each of those requirements are upfront and early is going to be very important for them.
I'd just like to thank Justin, Steve and Bryony for giving us your hour today. It was such a wonderful webinar, and I can see that we've got about an hour's worth of questions left here. So, so thank you to the audience for being so engaged and asking all of these great questions for our presenters today. If you would like your question to be answered and it wasn't today, please use webinars at legalaid.qld.gov.au. That's the best email address to send your question onto, and we'll be able to pass that on to our presenters. So thank you for linking in. Keep your eye out for the next webinar, and thanks to Bryony, Steve and Justin again.